you text?
You.
Sure what that means. What does that mean?
They have a defendant that was brought out here a week ago on CPS on back child support. They still out there?
Cool.
Jason or Delacey. And they wanted, and somebody's here to bond that person out. They didn't know if it was $100 a day still, or if the person had to pay the full amount.
Guess it depends on what the order says. Is it one of my cases or another judge?
It's Andrew Wilson.
I'll have to look that up.
Okay, because I don't have a computer with us today, but we're ready.
All right, who's up first?
Mr. Adams.
All right, you have Ms. Smith with you?
Yes, Your Honor, she's here. She is on her way.
This is cause number CR 22-49, State versus Chastity Renee Smith for docket call. Go ahead, Travis.
Good afternoon, Your Honor. It's come to my attention recently that Ms. Smith has two potential felonies that are unindicted that were for which she was charged within the last 6 months or so. Of course, I have the case that I'm here for today for her is now one of three. This one has been indicted. She's been arraigned. However, what we'd like to do is have this reset, and hopefully the DA's office will either indict or decline the two additional cases so that we will be able to come to some resolution for all of the business that she now has and may potentially have in the future before the court. So essentially, we're asking the court to reset us so that we can see what's going to happen with the other two cases.
Understand. State.
Yes, Your Honor. I was just looking at that today, starting to look at those cases to see what they look like to try and reach a global resolution on all the business that we have with Ms. Smith. So I'm in agreement with Mr. Adams.
Okay. Do you think 30 days is enough?
Yes, Your Honor. 30 days should give us enough time to know how we're going to proceed on the other two cases.
Mr. Adams, I've got 7th, 9th, or 28th. Earlier, we said you were why we set you on the 9th earlier today.
Yes, however, that's a morning setting, so I'd like to not have to, as much as I love it here in Canton and love to spend my money at your fine eating establishments, I'd rather not have to spend a whole day here. So I do have the morning free of the 7th, or the afternoon free of the 7th, rather.
7th, okay, that's fine. All right, court says to suspend then for November 7th. The 9th.
This is going to be docket call, Your Honor.
Docket call, yes, sir.
Thank you. Judge, I think that's all I have for you for the afternoon. May I be excused?
Thank you, Travis. Appreciate you.
Yes, sir. See you soon. Thank you.
Picture. Wait.
Who else is ready?
Mr. Richard Schmidt.
Richard Schmidt, come on down. Ryan Keith Collier, come on up. CR 22-126, CR 22-127, State versus Ryan Keith Collier for docket call. Go ahead, Mr. Schmidt.
Judge, at this point in time, we are announced ready for trial and ask for a special setting.
Okay. Mr. Schmidt, I look like I have an available date of May 6th. Next year,
May 6th?
May 6th, 5/6/24. State opposition to that date. Special setting.
May 6th should be fine for us.
State, any problems with May 6th? Special setting, Mr. Foyer.
No, Your Honor.
Okay, all right, court especially sets Mr. Foyer for trial on May 6th, 2024. Both causes. Mr. Schmidt, just for record purposes, let's go ahead and place on the record if there was a plea offer made by the state, if so, your client's rejection of the same acknowledgement of the court's policy on pleas after announcements.
Judge, there was a plea offer made by the state. My client does reject that. I have made him aware that the court's policy is not to accept plea offers after today's date.
The offer that Mr. Foyer has rejected. I'm sorry,
I can't hear you.
what was the plea offer that Mr. Foyer rejected?
35 years.
35 years. All right. Sports to note that on the record and we'll have this, as we said, special set basis.
Hey,
If there's any issues that arise in the case, we need a setting earlier than that, then you let us know.
yes, sir, will do.
Are you ready on Jamie Nash?
We are.
All right, Jamie Marie Nash, CR 22366. All right, please motion to revoke. Go ahead.
It is, Judge. We'll ask that Ms. Nash be set on the contested November docket day. Hopefully we will resolve it before then. I just got recently reappointed to Ms. Nash, so I'd like to meet with the state and see what we got going.
All right, well, we'll set Ms. Nash for contested hearing on November 30th. At 1:30.
Judge, we also had a writ on Mr. Williams. At this point in time, and Mr. Williams is in the courtroom, we're gonna withdraw that writ and proceed without it. And wow, that's not very articulate, but at the end of the day, we were withdrawing our writ for today's purposes.
It was effective, might not have been articulate, but it was effective. Okay. Court notes for the record, WR 23-79, that the writ has been withdrawn. All right, do you want to leave that pending, Mr. Schmidt, or can the court close that out?
Judge, the court can close that out. In the event we need to file an additional writ, we will as far as pertains to bond, but at this point, we could just close that one out.
Okay, all right, court will dismiss WR 23-7.
Thank you, Judge. I think that's all I have on your docket.
Yes, sir. Please, so appreciate it.
Thank
It's Mr. Patton, any ready?
Your Honor, we have not seen Mr. Patton. Ms. Barker is trying to call him to see if he plans on appearing. The defendant says he's not heard from him either.
Man, it's the second time the dates got switched over for the appointment, so.
And the defendant said this is the second time that he's been here that Mr. Patton has not been.
right, the last time it was, the court told him the wrong day.
Ms. Barker says he perhaps may still be in federal court. His secretary is calling him.
That's my attorney.
Okay, we'll stand. I see that the last setting, we entered an appearance notice for today at 30, so we'll stand in recess, give Mr. Pat an opportunity to zoom in or appear.
Okay.
Stand in recess.
Anything you say can be heard by anybody.
Don't talk right now.
Good afternoon, Mr. Patton.
Hello, good afternoon.
Hey, Mr. Patton, how are you? Do you need any time to talk with your client before we make any announcements? I can put you in a private breakout.
No, sir, I do have some information for him, but I need to go see him in person.
Okay. All right, I'm gonna go ahead and call this case then. This is cause number CR 22-390, State versus J. Warren Penny for Docket. Go ahead, Mr. Patton.
Your Honor, other than there's the last bit of discovery, I need a body cam, but I understand it's available. Other than that, we're ready to go.
Do you not have the body cam?
No, I've got everything but the body cam. I've got the dash cam of the stop, just not the body cam.
Okay. So I think the body cam was that admitted during the motion to suppress. No, that's something that I viewed.
Well, forgive me. It's probably that there's two things on the disc I can't open, and the only one I can think of, the disc I received from the DA, was the body cam, because I've watched everything else. It was made available to me, but for some reason, I don't know if I need a codex or something. I just can't get into it.
Okay, we were set for docket call today. Has an offer been made by the state that your client is accepting or rejecting today, Mr. Patton?
I was rejecting, Your Honor.
Okay, and I'd like to go ahead and put it on the record what it is that's been offered, make sure that that's the state's best offer. And if it's going to be rejected, that Mr. Penny understands it's before we not entertain a plea bargain after today. So what was the offer that was extended to Mr. Penny by the state, Mr. Patton?
It was 30 years, Your Honor.
30.
Yes.
Sounds like they're going the wrong direction if they want a plea agreement.
Mr. Penny, you're represented by counsel. Right? He's going to speak for you at this time. Okay.
Okay,
All right. So your client's rejecting that offer. He understands that the court will not entertain a plea bargain after today. Should we pass this date and set up a trial? Should there be an agreement, the court would entertain that on an open plea, but not a plea agreement.
Yes, Your Honor.
Okay.
Your Honor, may I speak, session?
No, sir. You may not.
All right.
I'm gonna advise you to follow your attorney and follow his advice. The court is going to set Mr. Penny on the rolling trial docket. Begin that on October 30th. And Mr. Penny will be on that until you reach the top 10. Of course, Mr. Patton, you're not required to be here on those dates. You would be notified once this case reaches the top 10. Once in the top 10, then I would expect you to appear because you could be liable.
All right. Thank you, Your Honor.
Right. If y'all want to discuss any more issues, then you'll just notify the state and you get this court calendar. Okay.
Yes, sir.
All right. Thank you, Mr. Patton. I appreciate you doing it.
Thank you, Your Honor.
Did we get a response on the motion to suppress reconsideration?
Yes, yes, I did deny that, Mr. Penny, and I've given a written order, and Mr. Patton has that.
Thank you.
You're welcome. All right, I believe that concludes our afternoon document. Mr. Abraham, am I correct?
Yes, Your Honor.
Okay, all right. I'm gonna go ahead and adjourn for the day. Thank you, sir. Appreciate it.